Hi, friends. Nathan Pierce here with Family Protection Ministries. Thanks for joining us today for the Front Line. I will be discussing a little bit about a Supreme Court case that favors parents. We'll be talking a little bit about God's faithfulness, and we'll talk a little bit about a bill in the legislature regarding parents and their control of their kids. So let's enjoy God's faithfulness today, and we'll be right back to talk about those things.
Welcome to the Front Line with FPM, where we talk about California politics, homeschool freedom, parental rights, and the family. I'm your host, Nathan Pierce, and thanks for joining us today. Let's jump right in and see what's going on here on the Front Line.
All right, so before we talk about legislation and Supreme Court, I want to preface everything with scripture from Lamentations, where it says, Yahweh is good to those who hope in him, to the soul who seeks him. It is good that he waits silently for the salvation of Yahweh. And this is a reminder on so many levels that God is our salvation, and he does save us. Throughout Scripture, we see God saving people in many different ways. And there's minor things that we would think of as small, things that we would think of as insignificant or focused on perhaps one person. And then there's the ultimate salvation of the whole world in terms of God's faithfulness and patience with those who seek him and who love him and who pursue serving him. And this scripture, Yahweh is good to those who hope in him, to the soul who seeks him, is a reminder that God is faithful with fulfilling his promises to those who hope in him, to those who seek him. It says it is good that he waits silently for the salvation of Yahweh. And this sometimes, I think of this verse in the context of the legislature, because sometimes we don't win right away. Sometimes it feels like we're losing. And sometimes it feels like these pieces of legislation that are coming against the family are just terrorizing our state and our country and our world. And yet, when we wait, sometimes we win a little bit later. Sometimes we win a victory a year or more later, which is going to be the case when we talk about this Supreme Court case. But ultimately, what we're waiting for is the ultimate salvation of Christ. And his salvation, his salvation is absolute and permanent. And it makes the things that I think of as being challenges in our lives, these pieces of legislation and threats to the family, these things are small in comparison, but all are things that are doable for God. God is not unable to achieve salvation in these small things or in the ultimate salvation, which is Christ sacrificing for our salvation, God sending his son to die for us so that we could live for eternity. And that is an incredible God glorifying salvation. And for us, it's the ultimate salvation, but yet at the same time, we need to not overlook these smaller things, these things that from one day to the next are God showing himself strong on our behalf. So remember that Yahweh is good to those who hope in him, to the soul who seeks him. It is good that he waits silently for the salvation of Yahweh. God is working, even when it feels silent. God is working. He has a plan for salvation. It may not look like our plan for salvation, but it is there. So remember that. As we go into this, I want to talk briefly first about a bill. AB 1955 was a bill a couple of years ago that was in the context of there were teachers in public schools in California that were aware that young people were going through either a mental change in terms of transgender ideas in their mind and going through that at school. Some others were going through actual physical transitions for their pursuit of becoming transgender. And in some of these cases, parents were not aware of it, but the teachers were. And the parents were not able to find out about it because the teachers were hiding it from the parents. And in some cases, the school board actually forced the teachers to tell the parents what was going on. And this became a big political issue, and ultimately a bill, AB 1955, was passed and signed into law by Governor Newsom that told school boards, you may not force a teacher to tell parents what's going on with their kids. So recently, a U.S. Supreme Court decision overturned that. They said that goes against what parents have a right to in terms of overseeing their kids' education, their kids' upbringing. And the School Boards Association, interestingly, when other platforms, other news agencies are saying that this is a terrible thing, that the U.S. Supreme Court would overturn this and force this on schools. You're not allowed to stop teachers from telling parents what's going on with their kids. For example, San Francisco Chronicle is telling everyone that that's such a terrible, terrible thing. And so it's interesting that the California School Boards Association has a very different perspective, and their idea and their headline is the Supreme Court strengthens parental notification rights for gender transitions. So they're looking at this from the perspective of the School Boards Association as this is strengthening parental notification rights for gender transitions. In other words, it's helping parents to become aware of what's going on with their children. So they need to be embracing this because this is good for parents. It's good for children. It's good for the school boards. And it gives the school boards the ability to tell teachers, no, you need to be engaging with parents. You need to be showing parents what's going on, and you need to be helping parents to be aware of what's going on with their kids so that they can engage with their kids on these topics, so that they can know what's troubling their children and know how to engage with them. That is fundamentally the issue, is that parents need to be aware of what's going on with their kids, and parents should be engaged with their kids on these topics as their kids are growing up. And in many cases, teachers, and in some cases, and in the situation with AB 1955, enough legislators in the California State Legislature, along with our governor, viewed it very differently, that is not the role of parents. It's the role of the state and teachers specifically to help children to grow up, to be understood for who they feel they are or ought to be, and that these children should be able to go to public school teachers for counseling and help and support, even when they are doing things that are going against what their parents have directed them to do. And they can get support to do that, to oppose their parents, to grow up in a sort of a second life separate from their families because they don't agree with what their parents want them to live. They don't agree with the way that their parents are raising them in their own homes. So they look to government school teachers as their support, as their protector from their parents' ideas. And this U.S. Supreme Court says, no, that's not how it needs to be. Parents are the first ones that are to be guiding their children. And so that's a really important thing to be recognizing here, is that the U.S. Supreme Court has acknowledged parents are are number one. They are preeminent in terms of raising children, not the school teachers. So neither, according to the California School Boards Association, neither the district court nor the Supreme Court invalidated AB 1955, which prohibits mandatory disclosure policies. However, the guidance, there's multiple bills sort of in conflict with each other here, and the order lifts a stay rather than resolves all the merits. In other words, the courts potentially will view the order as precedental, including the Ninth Circuit Court of Appeals, which is still set to hear the appeal in a couple of these cases. However, 1955, AB 1955, does appear to be operative law. However, local education agencies or public school authorities should watch for developments in this area. In practical terms, the court's order revives a district court injunction that prohibits the state from permitting the requiring local education agencies or public school officials to engage in, among other things, misleading parents as to their students' transgender status or refusal to provide requested information. This likely requires LEAs, or local education agencies, government school officials, to follow these obligations, all while navigating liability from multiple directions. So it's a complex setting, but the Supreme Court is recognizing the one thing, that you cannot have a teacher get in the way of a parent finding out what's going on with their child, and they absolutely must not be misleading parents as to their students' transgender status or refuse to provide requested information, which is what has been going on in California schools. So this is a good development from the U.S. Supreme Court. This is only impacting things going on in the public schools here in California, but it is important to recognize that this impacts the overall society and the societal structure in our state, and it's going to have impacts across the country. And we can see that by the fact that this is going to be looked at as a precedent. This is the U.S. Supreme Court that made this decision, and so we can make sure that this is not over. This is discussion, this argument of who controls the minds of our children is not over. It's still ongoing, and we will be watching to see how that gets responded to by the California State Legislature as they continue to work to have more control in the public school system in the state of California. And as we've been looking at legislation that's come out this year, we're seeing more and more bills that relate specifically to youth, younger children. Birth to 5 is that data tracking bill that wants to make sure that the state has access to information about children from birth until age 5, which is kind of scary that they're adding that in there, but this is related to the state's bigger picture, wanting an understanding of how do people function from birth through their careers, so that the state can study that information and understand what makes a successful person, what in their first year of life is leading towards success later in life, what in their second year of life is leading toward success in later life, and so on and so forth. And they want to have detailed information about what each person, what each human in California is doing from birth through their career, so that the state can understand and sort of lead people through what they view as success. So there's more and more coming out on these different bills, and so we need to track them very carefully and engage to make sure that they're not going to impede the ability of people that are not part of a public school system or a government program where the state is extracting information from people to, if people are not involved or engaged in those programs, can we live separate from that without getting our data eaten up by the state government? And so that's something that we're working very carefully on. We've dealt with this in a number of other bills throughout the years in the past, and been able to exclude those that are enrolling in private schools, private homeschool students, from having to submit data to these longitudinal database systems throughout the state of California. And we've been successful so far in that. So pray that we can be successful in this next round of bills as they pursue getting more data from more people. So that's it for now. Thanks for watching, and we'll see you again next time.
Thanks for joining us for this episode of The Front Line with FPM. For more information about the topics we discuss here, check out Family Protection Ministries at fpmca.org and subscribe to our channel.